Knowing your rights as an Indiana renter. This video is not a substitute for professional legal advice. This video does not create an attorney-client relationship, nor is it a solicitation to offer legal advice, but for education purposes only. This video was produced in June 2021. Laws change, and it is important to talk with an attorney about how current laws may affect your case.
Hello and welcome to the short video series, Knowing Your Rights as an Indiana Renter. In this video, you will learn more about your right to reasonable accommodations and modifications. Fair housing laws require applicants and residents with disabilities to be provided with reasonable accommodations as needed in order for them to have an opportunity for full use and enjoyment of their housing. What is a reasonable accommodation? A reasonable accommodation is a change, exception, or adjustment to a rule, policy, practice, or service that may be necessary for a person with disabilities to have an equal opportunity to use and enjoy a dwelling, including public and common use spaces. The accommodation must be practical and realistic. How does a tenant qualify for a reasonable accommodation? A tenant must be a person with a disability. That includes individuals with a physical or mental impairment that significantly limits one or more major life activities, individuals who are regarded as having such an impairment, and individuals with a record of such an impairment. How can a tenant get a reasonable accommodation? First, you must request the accommodation. Your landlord does not have a duty to assume one is needed. Next, indicate you qualify as a person with a disability. If requested by your landlord, you can provide a note from your doctor stating why the accommodation is necessary. Also, describe the change you are seeking. You'll want to show how the accommodation is necessary so you can use and enjoy your home or common spaces. Some examples might include support, service, or assistance animals for a disability, braille numbers on doors or common areas, a reserved parking space for someone who cannot walk long distances, a visual alarm system on smoke detectors, rent reminders when rent is due, allowing a person from the community to educate other tenants about certain illnesses or condition of the requesting tenant, or allowing assistance from a personal care attendant. People are sometimes surprised to learn that assistance animals are covered as reasonable accommodations. The animal can be called service, assistance, therapeutic, emotional support, depending on how the animal helps. The animal is not limited to dogs, but additional information may be requested by the landlord if the animal is unique to confirm the need for that animal. An assistance animal is not a pet, and a request for a support animal for that reason alone cannot be denied because pets are not allowed under the lease agreement. No pet deposit or additional insurance for the animal may be required. A certification showing the animal is used for service, assistance, or emotional support cannot be requested. However, a landlord may request a note from a doctor regarding the need for the animal. And finally, request the accommodation in writing. Sign and date the written request before giving it to your landlord. Be sure to keep a copy of the request for your records and the date it was given. Ask for a written response within a certain amount of time. Can the landlord deny the request? To deny the request, the landlord must show that the accommodation is not reasonable or it causes undue burden. A landlord may deny the request if its insurance carrier would cancel, substantially increase costs, or adversely change the policy because of accommodation. A landlord may request an alternative accommodation that would still meet the requirements. How are reasonable accommodations different from reasonable modifications? A reasonable modification is a structural change made to existing premises, occupied or to be occupied by a person with a disability so that the renter can fully enjoy the premises. Modifications can include structural changes to interiors and exteriors of dwellings and to common and public use areas. For example, the installation of a ramp into a building, lowering the entry threshold of a unit, or the installation of grab bars in a bathroom. How to qualify and request the modification are the same as with reasonable accommodations. However, a major difference is that your landlord must approve the structural change, and you may be required to pay for the modification. If you believe you may have been discriminated against due to a disability or because of your request for a reasonable accommodation, seek legal assistance. Thanks for watching and learning more about reasonable accommodations and modifications. Be sure to check out the other videos in the Knowing Your Rights as an Indiana Renter series. Videos are available on protecting yourself from eviction, understanding your lease agreement, your right to safe and clean housing, and housing discrimination.
This video is not a substitute for professional legal advice. This video does not create an attorney-client relationship, nor is it a solicitation to offer legal advice, but for education purposes only. This video was produced in June 2021. Laws change, and it is important to talk with an attorney about how current laws may affect your case. Many resources on this housing topic and others are available at www.in.gov/courts, www.indianalegalservices.org, and www.eskenazihealth.edu/medical-legal-partnership. Knowing Your Rights as an Indiana Renter video series sponsored by Eskenazi Health Foundation.